Right, it is 12 o'clock. Hello, welcome everyone. We are going to get started on January's Planning Lunches at noon webinar, Building or Development on Class 6 Roads or Private Roads. I am Brendan McDowell, a Principal Planner in the Office of Planning and Development at the New Hampshire Department of Business and Economic Affairs. I am joined by Jonathan Cowal, who is a Municipal Services Counsel at the New Hampshire Municipal Planning Association. We have a lot of information to go through, but before we dive into this topic, here is a reminder of how to use Microsoft Teams webinar controls. Please drop your questions in the chat, and at the end of the presentation, we will go through as many questions as possible. And yeah, with that out of the way, let's get into it. So, Jonathan, take it away.
All right, thank you. And thanks for having me. Happy to be here today to present. One of our most commonly talked about topics that we get is building and development on Class 6 roads. At NHMA, the Legal Services Department, we answer legal inquiries throughout the year from our members. And we also host a yearly training on road law called A Hard Road to Travel. And this topic in particular, development and building on Class 6 roads, is always a hot topic. And so I've got a lot of information here that I'm going to try to fit into this hour-long presentation. So I'm going to jump right into it. To get started, I think before we talk about anything involving municipal roads or highways, we need to clarify some road terminology, because I'd say that maybe the most misunderstood part of road classification is the terminology that we hear and that we use when it comes to roadways. And the terms, while they're thrown around in different ways, many times not always accurate ways, can cause confusion if we don't know exactly what it is these terms mean and how they can have a legal consequence depending on which term we're using. So the first is the term right-of-way. So a right-of-way is not defined within the New Hampshire RSAs. There's not a specific legal definition of right-of-way. For our purposes here in the state of New Hampshire, we pull this definition from case law. And there's this case, Gene versus Arsenault, which is an older case in the state where the court sort of created their own definition of right-of-way, and this has been cited over and over again. And what the court said is that a right-of-way is defined as a right to pass over another's land more or less frequently according to the nature of the use to be made of the easement. So this can refer to any number of legal rights for one person to cross over the land of another. It could be a deeded right of access. It could be a recorded easement. It could be some other type of legal or even sort of ad hoc agreement that one person has the right to pass over another person's land. Usually when we talk about right of way in the legal concept, we're talking about a private legal agreement between landowners. That term right of way, though, is also sort of thrown around when we talk about the full spectrum of a public highway, a class, 4, 5, or 6 road. A lot of times people will say, well, the right of way includes, the shoulder. It includes 3 feet on either side of the traveled portion of the road. It's where, trees will grow and shrubs will grow, that there's always a dispute as to whether or not the municipality has legal control over those. And so while we use that term right of way usually to talk about the entire legal roadway, for the most part, the legal definition of right of way involves this private contractual agreement between landowners. The term private road is probably the most misused term that we run into. Many people use it to refer to anything ranging from a discontinued road to a class 6 road to subdivision roads that are still under development that have not been accepted, otherwise known as paper roads. And while this term is used to sort of encompass all of those different types of roadways, realistically, a private road is in fact private property, which is very different from a class 6 road or from paper roads laid out on a subdivision plan waiting for acceptance by the municipality and development. From a legal definition, a private road is really nothing more than a person's driveway. It's owned by one or more individual landowners. They can post no trespassing signs. It has all the same legal rights as private property. The public does not have a legal right to access a truly private road. But the term private road is many times used to talk about any road other than, a class 4 or 5 road. And then finally, we've got public road, which are roads that are subject to reasonable regulation by public authorities. There's a duty to maintain them, and where the town or the city still holds a right of way. So for the purposes of development on class 6 and private roads, there's a distinction to be made between a class 6 road and a private road. And we're going to get to what the specific differences are between those types of roads in the next couple slides. So class 6 roads, these are a specific class of public highway. The public has a right to use a class 6 road. They're still within the full management of the select board. The only difference between a class 6 road and a class 5 or better road is the duty to maintain. And that comes from RSA 231:50. And the statute relieves towns and cities of all obligations to maintain and all liabilities for damages incurred on the use of a discontinued highway or highways discontinued, made subject to gates and bars. Here's two more terms that are important to understand the difference between discontinued and discontinued subject to gates and bars. A road that is discontinued subject to gates and bars is a class 6 road. The public still has a legal right of access to that road. You can put up gates and bars, but you can't close them or lock them to bar the public's right of way. It's more symbolic than anything. A road that's been truly discontinued, which we'll get to again in a second, is actually reverted back to private property. In either instance, there's no legal obligation for a municipality to maintain a private road, a discontinued road, or a class 6 road. Therefore, towns don't need to worry about any type of insufficiencies or damage caused on class 6 roads. However, if a town is performing a function on a class 6 road, they, one, need to make sure that they're not acting negligently, and two, they need to make sure that they're not incurring some additional type of liability by sort of implicitly accepting that road as something better than a class 6 road for the purposes of maybe maintaining it. And it's that portion, that concern about class 6 roads where you, as a municipality, don't have a duty to maintain them unless you start engaging in some type of maintenance or quasi-maintenance activity where you could be implicitly accepting that road as a better road, as a class 5 or better road. And it's that sort of factor that's important when it comes to your decision as to whether or not you're going to allow development on a class 6 road. Because inherently, if you're going to allow development, there may be some municipal activity that's necessary on those roads, whether it's just access with, from fire and emergency personnel, or perhaps something a little bit more. So what does discontinuance mean? There are two ways that a road can be discontinued. A road can be completely and absolutely discontinued, or it can be discontinued subject to gates and bars. Both actions require an act of the legislative body, which in most cases, or really in all cases, we mean a vote at town meeting. A vote to completely discontinue a road, whether it's a class 6 road, a class 5 road, or any other class of road where the public has a right of way, a vote to completely discontinue that road reverts that road back to private ownership. The abutting property owners regain their ownership rights of the land that the road crosses over, usually up to the center line. It doesn't technically become a private road because it was at one point a public road, hence the need to discontinue it. But for all intents and purposes, it truly is now a private road if it's been completely discontinued. That's different than a vote to discontinue a road subject to gates and bars. This simply creates a Class 6 road. As I said, it allows the installation of a gate and bar, but they cannot be closed because the public still has a right to access those roads. And so the reason why it's important to understand this distinction is because if you have a road that is someone seeking to build on it, you want to make sure whether you know how that road came into existence, whether it's a Class 6 road or a completely discontinued road, because the difference between a completely discontinued road and a Class 6 road for the purposes of development can have some effects on the considerations and the process that municipalities need to undergo when considering whether or not to issue building permits. So as I mentioned, the effect of complete discontinuance extinguishes the public's right to access that road for travel. They could technically be trespassing on private property, which is a criminal offense if it's been properly posted on a truly private road or a discontinued road. Discontinuing a road does not eliminate any private lots from being able to access their property along the former highway. So if you had a road that was at one point, let's say a Class 5 road maintained by the municipality, and the vote was to discontinue it, those property owners along that road don't lose their right to access their home. They don't have to then sort of retroactively apply to the select board for permission to have a pre-existing home on that road. There is this sort of grandfathering provision that comes into play for pre-existing homes on a discontinued or a Class 6 road. When it comes to regulating private roads, the only regulatory authority that the town has over a private road is to change the names and numbering of homes if they run in to conflict with E911 purposes. Towns cannot regulate private roads or totally discontinued roads in the same way that they can a Class 6 road. And that especially applies to maintenance. A town should never be engaged in maintaining, like plowing a private road, because then you could find yourself in a situation where you're incurring potential liability consequences. And so that's another important thing to remember when deciding whether or not you're going to allow development on a private road, because if you do, what's going to happen when these homeowners who've been allowed to construct on a private road are now crying afoul that they, physically can't access their homes due to weather conditions, and they're saying that the town has an obligation to make sure that emergency personnel can get through the snow to their homes. Are you going to be in a situation where you're considering now plowing these private roads, and then what does that mean moving forward as far as incurring liability and maintenance requirements? So it's important to understand the consequences of any type of maintenance on a private road. When it comes to the management of municipal roads, there's an overlap between authority, both there's separate authority and overlapping authority between the select board and the planning board. And so in general, when it comes to the creation and the maintenance of public roadways in a municipality, the select board is in charge of laying out of new roads. That's a specific legal process for the creation of a new road covered in RSA 231:8. The select board also accepts new roads under 674:40-A. Now 674, that's a land use statute. That's one of the many land use statutes we have, which delegates different authority between the land use boards. But within 674:40, it's the select board that has the final authority to actually accept a road, which has been created by the planning board in a new subdivision, for example. The select board's in charge of maintenance. The planning board doesn't control maintenance. They can set certain standards as far as construction and drainage and things like that, but the responsibility for actually continuing to maintain public roads lies with the select board. And then town road construction standards are also in the authority of the select board, obviously, to work with the planning board to make sure that the standards being set by the select board under RSA 41 and 47 are being applied by the planning board when they're approving new subdivisions, which is the primary responsibility of the planning board when it comes to municipal highways. It's approving new roads that are going to be constructed and created as part of subdivisions. The planning board has to plan for these new roads and how they're going to interact with the existing roads within the municipality. The planning board is in charge of considering capital improvement planning when it comes to new roads, subdivision and site plan road construction oversight standards, deciding whether or not there's going to be bonding requirements for performance bonds when it comes to construction of new subdivision roads and things like that. So that's the overlap when we talk about responsibility of the select board and the planning board generally when it comes to constructing new public roads. There's a bit of a different overlap when we talk about the development between the select board and the planning board when we're dealing with development on class 6 roads. And over here in this corner, I added the ZBA just sort of waving because they have a little bit of, they want to be part of the whole the process, but they have a very sort of limited role in this, but they're not to be completely left out. We always have to acknowledge that they do exist there. So when it comes to development on class 6 roads, the select board has to hold a public meeting and vote on whether or not they're going to issue a building permit. The planning board can't issue building permits on a class 6 road. That authority has been delegated by the legislature to the select board. The select board is also in charge of deciding if and what is going to be included in a waiver. If you're going to allow a building permit and development on a class 6 road, and you'll see this as we get into our later slides, it's an absolutely important thing to consider whether or not you're going to have an applicant fill out a waiver of liability. So all those things I've mentioned so far, the concerns about, are we going to have to maintain this road to allow emergency personnel to respond to a fire or to a medical emergency? And, what happens if the road is not in a good condition and one of our fire trucks gets stuck, or even worse, can't make it there in time or something like that? What liability is the town or city going to have in this example? So the select board has the authority to create a waiver of liability with specific terms that need to be signed and waived by an applicant in order to issue them a building permit. And then the select board can file that waiver with the registry of deeds to make sure that there's a legal record of that waiver on file somewhere if anyone ever tries to challenge that. The planning board, on the other hand, can meet and review and comment on an application for construction on a class 6 road and provide those comments to the select board to help the select board come to an educated decision as to whether or not they should, in fact, grant permission for construction. The planning board has the power to hold a conceptual consultation on subdivision applications and review those potential applications to see what type of process is going to be needed in order for the planning board to, one, accept the application as complete, and two, to make sure that we're not wasting people's time, that if there's things that they're going to need in order to properly be able to get the relief they're seeking, that they can know ahead of time what those things are. So when someone's submitting a new subdivision approval request to the planning board, and it involves potentially subdividing and constructing on a class 6 road, a road that there's no intent for the town to adopt as a class 5 road and maintain, a conceptual consultation is something that every planning board should probably be doing in those instances so that they can determine what the applicant's going to need to provide, and potentially flag issues like a zoning issue for the applicant to be aware of, so they know that even if the planning board approves their subdivision application, or even if the planning board is planning to approve their subdivision application, they may have to legally deny the application to send it to the ZBA to get a variance first. The ZBA could then choose to grant the variance, in which case the planning board would then be able to accept the application. So all of these things can be addressed at a conceptual consultation before the actual legal process gets underway, and we have some stricter, time concerns that come into play. So RSA 674:41 is the statute which primarily regulates development on Class 6 or private roads. And realistically, what this statute is a form of state zoning. It's the state of New Hampshire telling every municipality that they are not allowed to have local choice when it comes to deciding whether or not they're going to issue a building permit on a Class 6 road unless they go through the state required procedures. The statute is not dependent on the adoption or existence of a local zoning ordinance. You can't zone away these issues created by 674:41, nor the adoption of a local building permit process that municipalities have the option to adopt. You can't get around these regulations through any type of local option. In addition, the statute states that it preempts any less stringent local regulation, and therefore municipalities can't exempt specific lots from the necessary frontage on a Class 5 or better road, meaning that grandfathered lots are not necessarily exempt from the statute's requirements if they're seeking to do something like expand or construct additional structures or something like that. So there's not a strict grandfathering provision like there is with some other things, like a pre-existing non-conforming structure in a zoning issue. So what exactly does RSA 674:41 do? The statute begins by saying the following sentence: from and after the time when a planning board shall expressly have been given the authority to approve or disapprove plats by a municipality, no building shall be erected on any lot within any part of the municipality, nor shall a building permit be issued for the erection of a building unless the street giving access to the lot upon which the building is proposed to be placed is a Class 5 or better highway. So this is a frontage requirement in its, in its simplest form. RSA 641 is a frontage requirement. It requires that all new buildings, as well as remodels, additions, or conversions of property from seasonal to year-round, have proper frontage on a Class 5 or better highway. Also, the first sentence in paragraph 2 of this statute speaks of the structure as or part thereof, and that terminology, structure or part thereof, implies that any physical expansion of an existing structure would trigger this obligation to comply with the Class 5 or better frontage requirement. So what is a Class 5 road or better? A Class 5 road is a road that's been previously laid out or appears on an official map or has been accepted legally by the Select Board in its authority to accept new highways. RSA 674:41 says the street giving access corresponds to its location and lines with a street shown on the official map in RSA 674:10, or a street on a subdivision plat approved by the planning board, or a street on a plat made by and adopted by the planning board, or a street located and accepted by the local legislative body of the municipality after submission to the planning board, and in case of the planning board's disapproval, by the favorable vote required in RSA 674:40. So the planning board plays a big role here in laying out, or in the subdivision process, where new roads are planned for, and they are laid out as part of the subdivision process with the intent that they are going to be accepted as new roads by the municipality. The problem that sometimes arises when we talk about the classification of roads, or roads being Class 5 or better, happens when the planning board approves subdivisions with newly created roads, but there is not an agreement from the Select Board to accept those roads as town roads. Because again, if you remember our Venn diagram, only the Select Board has that legal authority to accept a new road as a as a class 5 or better road, as a town road for the purposes of public access and maintenance. So when the planning board is engaged in laying out new roads through the subdivision process, they need to make sure that the process is being followed so that the roads are being constructed to the proper standards necessary for the town to accept them. And so that when the subdivision is complete and the building permits are ready to be issued, the town is accepting, the select board is accepting those new roadways. If that doesn't happen, you find yourself in these situations where subdivisions are created, sometimes large subdivisions with an access road or roads that have never been accepted by the municipality. And there's this sort of misunderstanding or like a don't ask, don't tell attitude of whose responsibility it is to maintain those roads. And sometimes the subdivision, the people who own property along the subdivision or within the subdivision will privately contract for those roads to be plowed or maintained, or they'll have an agreement amongst themselves to do it. But as the years go on and as those property owners change hands and things like that, sometimes those agreements, are forgotten or fall by the wayside, and the new owners are now crying foul that the town needs to maintain this road. And if there's confusion as to whether or not the road was ever actually accepted by the municipality, you may find yourself in a situation where the town is now needing to maintain those roads in order to prevent liability concerns because waivers were never filed. When the subdivision was created, because they didn't know that these roads were going to ultimately remain private. And now there's liability on the town stamp from the town's perspective, and perhaps significant maintenance issues that were not addressed through private agreements that's now on the taxpayers to make up for. So I guess the moral of that story is the planning board, while the planning board has authority under 674-41 to lay out roads that will potentially qualify as a class 5 or better road for frontage requirements, they need to be doing so in conjunction and cooperation with the select board to be sure that these roads, if they're intended to be accepted as public roads, class 5 or better roads, are actually accepted. So we don't find ourselves in situations several years down the line where we're confused or in a difficult situation determining the actual classification of a subdivision road. So why does RSA 674-41 limit building? Well, for most of the reasons that we've been talking about so far. The purpose of this limitation on building on Class 6 highways is to provide against such scattered or premature subdivision as would necessitate the excessive expenditure of public funds. This is language from a court case, Glick versus Ossipee, where the court provided that explanation as to why RSA 674-41 exists. And the key here is the necessitate the excessive expenditure of public funds. And so that's the protection here, is that we don't want to find ourselves in a situation where a class 6 or private road, which had no obligation to be maintained by the taxpayer dollar, is now needed to be maintained by the municipality for whatever reason. And that road has fallen into complete disarray. It has significant maintenance requirements. It has significant costs associated with getting this road back up to class 5 standards or something like that. All that money comes out of the town account, which is the taxpayer dollars. So we want to do our best to prevent a situation like that from happening, or to mitigate the costs of something like that happening down the road. Consequently, municipalities are not obligated to allow construction on class 6 or private roads. The municipalities are empowered to regulate by means of a zoning ordinance frontage requirements which exclude access routes unsuited for travel. And the basic purpose of requiring frontage is to ensure that a dwelling may be reached by the fire department, police department, and other agencies charged with the responsibilities of protecting the public peace, safety, and welfare. So not only does RSA 674-41 provide this state zoning option, or not option, the state zoning mandate really, to limit construction on class 6 or private roads, municipalities are not obligated to allow construction, even if somebody follows the procedure of going before the planning board and the select board for comment, approval, and issuance of a building permit. Municipalities can also regulate within their zoning ordinance other frontage requirements, which may make it impossible without a variance or something like that to get a building permit on a class 6 or private road. Those restrictions can always be more stringent than state law, RSA 674-41. They can't be less stringent than state law. So what about grandfathering? We mentioned it a little bit. Some municipal ordinance, zoning ordinances will grandfather existing lots when it comes to allowing them to be exempt from new requirements of a zoning ordinance. However, these zoning clauses do not make existing lots exempt from that frontage requirement under 674-41. In paragraph 3, it says this section shall supersede any less stringent local ordinance, code, or regulation, and no existing lot or tract of land shall be exempted from the provisions of this section except in accordance with the procedures expressly set forth in this section. So what this means, again, is that if there is a pre-existing lot on a class 6 or private road, and that person is seeking some sort of expansion, they want to expand the size of the home, they want to add an accessory dwelling unit, they want to demolish the house and build a bigger one, they want to convert it to a full year-round dwelling unit. All of those actions will still need to comply with RSA 674-41 and the procedures outlined in that section of the RSA. They can't say, well, my house already exists here, so I should be able to do what I want without having to comply with 674-41. RSA 674-41 applies to building permits in general. The statutory title implies that the statute only applies to subdivisions, but that's not true. RSA 674-41 is not limited to only those building permits issued through the subdivision process. There was some confusion about this, which resulted in a court case. It was challenged in this case of Vashon versus the town of New Durham zoning board, and the challenger lost. And what the court essentially ruled in that case is that the language of 674-41 applies to issuing building permits for new subdivisions and issuing building permits for pre-existing lots not part of subdivision. So even if the lot is a pre-existing individual lot and the owner of that lot is seeking just a building permit from the building inspector or the select board to construct a new home or to make a modification to an existing home, if that lot does not have frontage on a class 5 or better road, they're still going to need to go through the process outlined in order to get that building permit. So what are we talking about when we talk about proper frontage on a class 5 or better road? The amount of frontage required is governed by the individual municipality's zoning ordinance. So the statute is concerned with the location of the frontage. The New Hampshire court once said that the frontage is the property's location, making it more a creature of geography than geometry. So inherent in most municipalities' definition of frontage is that the frontage must be on this class 5 or better highway because of the state regulated zoning. So there's some overlap there between state and local law. The 674-41 is concerned with ensuring that there is proper frontage on a class 5 road, but not necessarily how much. The amount of frontage that's required on that road is governed by your local zoning ordinance, not statute. So this is where we have these examples where your local zoning ordinance could come into play to maybe further limit somebody's ability to construct on a class on a road, a class 6 or a private road, and require variances if the select board is planning on approving it, because a lot may have a tiny sliver of the lot touching a class 5 road, which would therefore satisfy the requirements of 674-41. But if your local zoning ordinance says that there needs to be 300 feet of frontage, well, now there's an additional hurdle that the applicant needs to overcome in order to be granted that building permit. And the process for that is outlined or lies with the ZBA and local zoning. So this is why it's important to know your local zoning ordinance. The planning board, for example, can't prove a subdivision that would not comply with a municipality's zoning ordinance. If the application for a subdivision runs afoul of your local zoning requirements, the planning board's obligated to deny that application subject to obtaining a variance. The board or code official must determine how the zoning ordinance defines the dimensional requirements for subdivided lots. Does the ordinance say that frontage must be on a class 5 or better road? If the zoning requires minimum frontage on a class 5 road, then a variance would be required from the zoning board of adjustments before the board could approve that subdivision. Does your ordinance simply say that frontage must be on a public road? Here's where the terminology comes into play again. If it does, a class 6 road is a public road. Therefore, maybe that would qualify under your local zoning ordinance. However, a private road is not a public road, so it would not. Thus, if you have somebody who submits a subdivision request for the planning board, you really need to know these road classifications. Is the subdivision being requested or the building permit being requested on a truly private road, or is it on a class 6 road? Because one's a public road and one is not. And that may be a very, very key distinction in your zoning ordinance, whether it uses the term public road or it actually uses a class definition term like class 6 or class 5. So it's important to be precise with your language and to make sure that the language of your zoning amendments and zoning articles are consistent with the language that you're intending to use and actually accomplishes the goal that you wanted to accomplish. So what are the minimal steps required if your municipality does want to allow construction on a class 6 or private road? The first is that the governing body, after the application has been reviewed and commented on by the planning board, votes to authorize a building permit. Once the planning board has provided comment and the select board has voted to approve issuing of a building permit, then the municipality has to worry about potential liability issues. The municipality really should clearly disclaim responsibility for any type of maintenance of a private or class 6 road that's being constructed upon and relinquish themselves of any liability for damages resulting from any use of that road by municipal equipment, especially like a fire truck or some of these more expensive pieces of municipal equipment that may need to access this road for the purposes of providing necessary or life-saving services. And finally, as we talked about before, you want to make sure that the applicant consents that this waiver of liability will be filed with the Registry of Deeds so that notice can be placed to any future purchaser of that property. Anybody who wants to purchase this property down the line can't buy a pre-existing home on a class 6 road and then claim that they had no idea that the town was not going to maintain it and not going to may potentially not be able to provide some type of emergency services and say, well, you made that agreement with the first guy, but not with me. So therefore, it doesn't apply. If it's recorded at the Registry of Deeds, there's a legal presumption that a buyer does their due diligence and knows whatever attachments or conditions come with the property that they're seeking to purchase. So what are some things that you want to consider from a municipal perspective when you're deciding whether or not you're going to allow development on a class 6 or a private road? And maybe the most obvious one is the condition of the road. What is the width and the grade of the road? What's the drainage infrastructure that's already in place? What changes might be necessary to the road in order to make it accessible, not just for emergency personnel, but even for the person seeking to purchase it. How are they going to be able to access their road or their dwelling? Is it going to be a safe road for them to travel? What type of demand will this place on public services if somebody is allowed to develop here? Is they're going to start claiming that a school bus needs to go down this road or something like that. And then what is the likelihood of future layout in connection with existing roads? Are you creating a situation where you're going to start allowing more and more construction on this particular road, and then people are going to start wanting to branch off and subdivide further and create more Class 6 or more private roads that people are going to seek building permits on? How will this snowball is a legitimate question to ask yourselves when deciding whether or not you're going to grant an exception to the state zoning of 674-41. Terminology again. So right of way. A right of way cannot be the only access to the property. So when we talk about that legal definition of street giving access, that means a street or way that abuts the lot and upon which the lot has frontage. And this definition was a legislative change in response to a Supreme Court decision in the Westmoreland case, where the court held that an easement over private property technically constituted sufficient access under the original language of the statute. And so the legislature was unhappy with that interpretation by the court. And so they decided to change the definition. And so what this means is that if somebody is accessing their lot through a private right-of-way agreement, which is usually going to be an easement, but there's other ways in which somebody could have some private agreement. Sometimes it's deed covenants. On a deed, you might see a covenant which says that the owner of Blackacre has a legal right to walk through the eastmost portion of Whiteacre to access the lot known as Greenacre. You get these crazy terms and covenants within deeds. And somebody might come to the town and say, look, I have a legal right-of-way or legal rights to access my property via this easement or via these covenants. And so therefore, I'm qualified to seek a building permit for construction on a Class 5, Class 6 or private road under 674-41. That's no longer the case. There needs to be either full ownership of the property providing access. Even if it's a private road, it still needs to be legally owned, not an easement or a right-of-way. Or it needs to obviously be a Class 6 road, which is a public way. So be careful. And this is another reason why conceptual consultations are a great idea, because you can have an applicant bring in documentation showing what their access to their lot is. If they don't have frontage on a Class 5 road, they need to bring in some type of documentation which shows what road is giving them access. And then the planning board can take a look at that and say, okay, the road isn't they have no access or frontage on a Class 5, but they do have access on a Class 6, or they do have access on a private road. If their only access is a right of way, the planning board can say, listen, we don't even have the authority to grant you approval for a building permit or for subdivision because you don't have a legal access under 674-41. Your first step before you even come to us is going to be to go to your neighbor and negotiate a transfer of property, a sale of land, or a legal agreement to transfer property ownership rights to you of this deeded right of way, so that you now at least technically have a private road that you can then seek the proper permissions for. So some considerations for the planning board to be aware of. We talked about conceptual consultation. It's probably your best tool when it comes to especially subdivision applications that include Class 6 or private roads. Planning board should know that only the select board can issue a building permit on a Class 6 road. Therefore, it should be made clear to an applicant before the planning board the limitation of the planning board's authority. They can comment and they can say that they will approve the subdivision, but the planning board doesn't have the ultimate authority. They need to let applicants know that the final say is going to rest with the select board. And planning boards need not worry about being held to any of their statements necessarily during a conceptual consultation, because the statute clearly states that the topics discussed in a conceptual consultation are not going to be legally binding. It's for the benefit of the applicant. It's not to sort of bind the hands of the planning board moving forward. The planning board needs also to consider their master plan, right? Your master plan is a guiding tool for the planning board to use as far as development moving forward. And so the master plan needs to be considered by the planning board when choosing whether or not to recommend or provide certain approvals of these type of developments. Remember, the purpose of 674-41 is to provide against scattered or premature subdivision of land that would cause some type of danger to health, safety, or prosperity by any type of lack of water supply or drainage, transportation, schools, fire protection, or other public services, or necessitate excessive spending of public funds in order to provide those services. So those are the duties we're looking to protect, and the first line of protection for those duties comes through the planning board. The focus of the inquiry of the planning board is upon the effect of the proposed development on the community, not necessarily the effect of further development in general of the community. And that's language from the court in interpreting these cases. So if it's the consensus of the planning board at conceptual consultation that the subdivision is scattered and premature, then the planning board should not be shy to make that opinion clear to the applicant, even at the conceptual consultation process, to say, it is our opinion that this is not an appropriate subdivision to approve at this time, given the various concerns that are listed here, so that if even if you choose to submit, there's not a high likelihood that you're going to receive the approvals that you're seeking. If the board is prepared to grant approval of the subdivision, the board should only grant subdivision approval subject to the condition precedent. That means a condition before final approval, that before the plan will be signed and recorded at the Registry of Deeds, the subdivider must first obtain approval of the issuance of building permits from the select board on a class 6 or private road, and that the applicant will that upon granting final approval, the applicant will agree to have further conditions associated with the subdivision limiting municipal liability. So there's sort of two important things to remember there, is that the first, it needs to be made clear that before final approval by the planning board of a subdivision application, the person needs to obtain select board approval for building permits. Not only will this trigger the applicant's awareness that they need to apply to the select board, but it makes it clear to the applicant that the planning board can't issue final approval until a different municipal entity provides that last remaining piece. And then when it comes to conditions subsequent, including within the approval conditions that the applicant, the subdivider, waives liability for maintenance and future construction and things like that, that's sort of like a doubling down of the waiver filed with the Registry of Deeds by the select board. It's a reiteration of those same concerns and conditions as conditions on subdivision approval. And it's sort of just another, check the box twice to make sure that you're not in a situation where anyone can claim ignorance to those conditions. As we mentioned, the landowner must execute and record a release and indemnification, and that needs to be recorded with the Registry of Deeds. Any item recorded at the Registry of Deeds, as I said, will bind future owners. It's necessary to protect the municipality from potential liability, and it's make sure that they agree to do it prior to granting of the building permit, because if you don't make them do it before you give them what they want, they're not going to do it after you've given them what they were looking for. Some common terms that we recommend including in such a waiver would be that the municipality assumes no responsibility for maintenance, including plowing or liability for damages. The landowner is responsible for maintaining the road and the access to the property, and releases and discharges the municipality from maintenance obligations, or for providing any type of municipal services, including police, fire, and ambulance services. The landowner would agree to indemnify the municipality from claims either brought by the landowner or third parties arising out of the use and occupation of their property and the maintenance of the road, and that the landowner is responsible for transporting any children who are living at the home to the nearest regular school bus stop. What happens if the application is denied? They could appeal to the ZBA. RSA 674-41 allows the ZBA to make a reasonable exception to some of the requirements of RSA 674-41. The ZBA may issue the building permit directly on appeal and subject to conditions if they choose, if it finds that issuing the permit will not distort the official map, increase the difficulty of carrying out the master plan, or cause hardship to the future purchasers or undue financial impact of the municipality. So there's similar considerations that the ZBA needs to take into consideration. The decision to not issue a building permit on 674-41 is an administrative decision. It's a decision of an administrative official. That is a qualification for the ZBA to reconsider. The ZBA, as we say, is a safety valve for property owners to seek an appeal of their constitutional rights to use private property. And so an individual could appeal that decision to the ZBA, but the ZBA is held not only to the 5 standards of granting a variance, but also to the same sort of considerations that the select board has when determining whether or not this one particular individual meets the criteria to be granted an exception to the rule. So what must the applicant demonstrate under 674-41 paragraph 2 in an appeal to the ZBA? So the applicant must demonstrate practical difficulty or unnecessary hardship, and the circumstances of the case do not require the building structure or part thereof to be related to existing or proposed streets. What does practical difficulty or unnecessary hardship mean? It's not defined clearly in the statute, but we probably have a decent idea of what it would mean, and that comes from a series of cases. And what it essentially boils down to is that for this specific individual, there is some characteristic of their property or of their individual circumstance, which makes the denial of this relief, this building permit in this example, extraordinarily difficult for them that wouldn't be applicable to other similarly situated or similarly located property owners. So there needs to be some type of, unacceptable hardship associated with this particular circumstance to meet that hardship test required for granting any type of variance. A ZBA decision denying relief under 674-41-2. I mentioned the Vachon versus New Durham case before. In this case, the ZBA made a decision upholding the select board's denial of a building permit. This was affirmed when the ZBA found that due to bare rocks, narrowness, swampy areas, seasonal flooding, that the road was probably the worst Class 6 road in the town. The ZBA found that the police and fire and rescue would have serious difficulties in reaching the property, and that there would be substantial increased risk for the inhabitants. There's an increase in possibility for the financial impact to the municipality due to the injury to town employees or town equipment. The ZBA also found it would be inconsistent with the town's master plan to allow erection of the plaintiff's buildings. All of these factors now, with the change in the law, need to be included in a written notice of decision, a written denial issued by the ZBA outlining all the reasons why they were denying this person's relief. So that's important when the ZBA is considering an appeal of administrative decision. Whether approving or denying, they need to provide written findings of fact citing the reasons for their ultimate decision. There's an exception under RSA 674-41-2A for the legislative body. And the legislative body is the term we use in most instances to refer to the town meeting, the voters. In cities or charter towns, the legislative body is sometimes the councilors, but for the most part in New Hampshire, we're talking about town meeting. So this is another way for a lot to be exempted from the frontage requirements under the statute. The legislative body, town meeting, or city council may vote in the same manner as it would vote on a zoning ordinance to grant an exception from the law for any particular lot, which would include something like an island lot, for lots that are only going to be serviced by boats. Obviously, they don't have frontage requirements. In a town meeting vote, the vote may occur at either an annual or a special meeting, and the question must first be submitted to the planning board for its approval. If the planning board approves the warrant article seeking the exception to this statute, then a simple majority vote by the legislative body is all that's needed. If the planning board does not approve the proposal, they would mark that on the warrant article, and a 2/3 majority vote is going to be needed to overturn a disapproved warrant article seeking an exception. Okay, so we got through all that information. I know that was a lot. I'm going to try to take some questions now. Here's my contact information. If you have legal questions or follow-up questions on this presentation, please don't hesitate to reach out to our legal inquiries department, or call our legal inquiries line, and myself or attorney Stephen Buckley would be happy to take your calls. Okay, so what do we want to do for questions? Are we going to go through the chat or?
Yeah, so yeah, thank you once again, Jonathan. Yeah, I was going to start kind of at the top of the chat and work my way down. We've only got a couple minutes here, but so we'll just get into it. So the first question I see from Steve. Oh yeah, if you want to pop open your chat too, we can kind of follow along. Yeah, first question is from Steve. Is abandoned the same as discontinued?
So there's no such thing as an abandoned road in New Hampshire law. You can never extinguish a public's right of access simply by not using the road. There are roads in the state which may be so overgrown with trees and shrubs that it looks like it's just part of the forest. If it was never discontinued by a vote of the legislative body, it's a Class 6 road. So you could technically try to drive a car over that. But there's no abandonment provision in the law.
Okay. And then the next question we've got is from Ed G. Does a town have any responsibility to maintain a Class 6 road that is used to access a home in another town? Yep. The town in question does not allow building on Class 6 roads.
So no, a town never has a legal obligation or responsibility to maintain a Class 6 road, whether it's their Class 6 road or it travels into another municipality. The only time municipalities may maintain a Class 6 road, and I didn't include it in this presentation because it's a whole nother section of the law, but you can declare a Class 6 or private road as an emergency way. And sometimes when we see that happen is when you have a road that is an important connector between sections of the same municipality or one municipality to another. And it's technically the quickest route from point A to point B for certain emergency responses. If that's the case, there's a whole provision in the statute to declare this road an emergency lane, in which case the town can then provide some maintenance, including plowing, in order to allow emergency vehicles to access it without incurring further liability. But for the most part, there's never a legal requirement for maintenance on a Class 6 road.
Right. Then the next question's from Pam. She said, so town roads don't have to go to town meeting vote, ? Example, subdivision was approved with private road and residents now want it to be a town road. Also, planning board can outright approve a new road in a subdivision.
Okay, so I'll start with the last piece. No, a planning board can never approve a new road in a subdivision. If you mean by approve, accept it as a public road, Class 5 or better. That authority only lies with the select board. You do not have to go to town meeting to accept a new road. The select board has several different methods of authority under their inherent power to manage town roads to accept a new town road without town meeting approval. However, one of the ways that new roads can be created is through a petitioned layout. And that is where any single citizen can petition either the select board, or 25 registered voters can submit a petitioned warrant article to town meeting to vote for a new road to be accepted. Now, I think I'm almost certain that the authority to accept new roads, because it's designated with the select board, is not an authority that the town meeting can supersede. So if you submit a warrant article at town meeting telling the town to accept a new road, I believe that it would be advisory only because the select board still has final say. But there's a petition process which allows somebody to essentially petition the select board through, more or less a petitioned warrant article. It only needs one signature to petition the select board to lay out a new road. And that's usually what happens, is where the residents on a subdivision where their subdivision road was never accepted upon creation of the subdivision will petition the select board to accept it. And there's conditions that need to be met. There needs to be occasion to accept that new road. There can be conditions attached to it, but that would be an example of the citizens petitioning the select board to accept a roadway. But town meeting is not inherently granted the authority to accept new roads. That lies with the select board.
Okay. So so we're at 1:01 p.m. right now. Do you and we have more questions than we can oh, Tim is asking if we could put up slide 13 again. We do have a lot more questions. Did you want to answer one or two more, or did you see any
Sure.
in there
Yeah.
that did you want to take a look and
I'll go, I can answer a few more. I'll go back to 13 and I'll see if I can run through some of these maybe a little quickly. Is the town legally required to supervise improvements associated with a class 6 road building permit? The the town, so no one can ever alter a class 6 road unless they have approval by the town. So even if they're an abutting property owner on a class 6 road, they can't make improvements to the right of way without seeking select board permission. If the select board or planning board requires certain improvements to be made to the road in order for it to meet certain standards to issue a building permit, then yes, the select board can supervise or even provide certain requirements that the property owners need to adhere to in order to satisfy the conditions that are being set. Should a variance when needed to construct on a class 6 road be obtained prior to the select board meeting on the building permit? Technically, in order to get a variance, you need to be appealing a denial of an administrative decision or appealing some other, a denial of the planning board. So the strictest legal process is to appear before the select board, for example, seek a building permit, get denied because of something in the zoning ordinance, and then appeal that decision to the ZBA. Towns don't always follow that because sometimes they'll flag the issue ahead of time and say, well, you're going to need this variance. You might as well go get it. Technically, because the ZBA is an appellate board, it makes the most legal sense and it's the cleanest process to get a denial from the select board first and then go to the ZBA. Are all class 6 roads considered discontinued subject to gates and bars, or can there be a class 6 road where gates and bars are not permitted? The gates and bars is just sort of antiquated terminology. It's really symbolic more than anything. Most class 6 roads in the state don't have gates and bars. I suppose you could always put them up, but they really act as nothing more than a street sign, more or less. So it's really just a terminology issue. Can building permits be issued on an approved subdivision where the roads have not been accepted by the town without 674-41 approval? So no. Well, yeah, hold on. Can building permits be issued on an approved subdivision where the roads have not been accepted by the town? Yes. So this is what we talked about in that in one of my previous slides. the definition of the class 5 or better road within the statute provides several descriptions of roads which haven't been fully accepted. That's when I went through that whole spiel about why this planning board and the select board needs to be on the same page about whether roads are going to be accepted or not. It's because roads appearing on an official map or on a subdivision, an approved subdivision approval, can be issued building permits. And then you could find yourself in a situation where the road has not been accepted as a class 5 road. So you want to make sure that the two public bodies are on the same page. But can any class 6 road have unlocked gates and bars? Yes, they all have to have unlocked gates and bars. All right, this is more discussion on gates and bars. Quick clarification, please. So a deed recorded right-of-way is mandatory for the planning board, select board to even consider a building permit, assuming the lot in question has no frontage? No, a deed recorded right-of-way is not legally sufficient for the select board to even consider issuing a building permit. It has to be a class 6 or private road giving access. Can an approved variance be used to issue a building permit that meets all other ordinances except for frontage on a class 6 road? Also, where a driveway permit is required for a building permit, can it be along a class 6 road? So yet a driveway permit can be issued if a building lot is approved. I'm not totally sure what this question is saying, but I guess what I would say is that you can't issue a building permit unless all aspects of the zoning ordinance have been complied with or issued a variance. There could be multiple zoning issues at play, not just frontage on a class 6 road, but there could be dimensional requirements or the amount of frontage. A person needs to get all the necessary relief or variances in order for them to be in complete compliance with any applicable zoning ordinance and the provisions of 674-41 before the select board can issue a building permit. When the proposal is a multi-unit subdivision, the planning board does do review and approval, but if it is a request for a residential structure on a pre-existing but non-conforming lot, the planning board does not review it. So how can the planning board weigh in? I think under the language of the statute, 674-41 gives the planning board the right to review a building permit request in a lot like what you described, to provide their comment to the select board. They're still reviewing this proposal for all the conditions we talked about when it comes to premature development and potentially spending excess public dollars. Even though it's not a subdivision, 674-41 triggers the need for the planning board to provide comment before the select board can consider granting approval. If the town is maintaining a class 6 road, who is responsible for maintenance? No one. Does a discontinued road allow for public access for eternity? A discontinued road, truly discontinued, grants the abutting property owners legal rights to access their property for as long as they own that property. As long as that property is in existence, it's a private property right to access your dwelling. All right, so I think that covers it. Everything. Sorry for that quick run through, but I think we got everything that was asked.
Yeah, I think we did. That was that was fantastic. Great lightning round there at the end. So yeah, well, thank you again, Jonathan. Thank you everybody for attending, and yeah, I hope everybody has a good rest of the week. And yeah, tune in next time for our next webinar. All right, thanks
Thank you very
everybody.
much.